Folks, welcome to the Government Accountability Project's People's Forum on the East Palestine train accident, which has had a tremendous caused tremendous damage to the community. Government decision makers, government authorities, and lawyers are on the verge of finalizing decisions which could permanently resolve a lot of the implications and consequences. We think it's essential that they make fully informed decisions. Everyone from the residents who have to decide if these settlements are acceptable, and the authorities to make sure they've made the right choices. I'm going to start with a few administrative matters, including kind of a boilerplate legal disclaimer that the views and opinions expressed by the panelists today are their own, not those of the Government Accountability Project. This forum does not involve attorney-client relationships, solicitation of legal advice. Anyone acting on today's information should first seek qualified, trustworthy counsel. The second administrative matter is for the panelists. Please keep your chat boxes open. Sydney Johnson of our staff is going to help you keep track of time limits, which we have to enforce. If you're not speaking, put it on mute. If you're not on the panel that's speaking, please turn your camera off. Third is for our audience. Today's forum this is just an introduction to 67 exhibits and 641 pages of evidence that we're sharing with the courts and the Department of Justice, because we're not convinced they were aware of it before they're making judgment calls for resolution. You've all received them. And this is just kind of the tip of the iceberg of our investigation over the last year. There's another 20 affidavits in the wings. And finally, if you've submitted questions and they weren't answered, or you have new ones today that aren't responded by the panelists, you have been heard. Government Accountability Project will get back in touch with you and get you those answers. The results of our investigation so far are that the federal government has engaged in a Dr. Jekyll and Mr. Hyde response to the East Palestine accident. Dr. Jekyll is represented by the National Transportation Safety Board and its chair, Jennifer Homendy. Although she was subjected to personal threats, she declared that the handling of this accident was unconscionable, and the NTSB is impervious to anything but the truth. What a public servant. By contrast, the Environmental Protection Agency has been Mr. Hyde. They've had a determined, aggressive stance of not wanting to know with the public. They were passive when Norfolk Southern pressured to burn the chemicals instead of the normal safe methods. They delegated fact-finding to those who were responsible for creating the public health threat. They violated their duty to warn, their legal duty to warn, instead repeatedly stating that the air, water, and even gardens are safe when they're not. And then in ultimate irony, they've been bragging about their massive cleanup effort for a public health threat that they keep insisting never existed. In short, the EPA is fiddled while the residents of East Palestine got burned. Yet there seems to be a rush to judgment. Residents need to to make decisions whether to accept the settlement on property damages in 4 days. They only have about 2 months to make permanent medical decisions about their lives. The government's only giving a little over a month before it finalizes the settlement. This forum is to make a public record of the truth, the whole truth, and nothing but the truth, for citizens to make informed decisions, whether it's time to stop fighting back. I'd like to introduce our first panel. It's the residents from East Palestine that we believe are illustrative of the public health consequences. Then if Lonnie Miller is here, we can start with her and those folks can catch up.
Hi, it's nice to see you guys. Thank you so much for what you're doing. I can go ahead and read part of my testimony that I gave when I testified in front of Senator Mastriano in March of this year at his investigative hearing in Darlington, PA. Hello, my name is Lonnie Miller, and I am a victim of the Norfolk Southern toxic hazardous chemical disaster, which took place in East Palestine, Ohio on the night of February 3rd, 2023. The home I shared with my husband and son for the last 30 years is no longer our forever home. Our home was 1,800 feet from the point of derailment, and less than 1,200 feet from where toxic chemicals burned were extinguished and then intentionally detonated, resulting in the uncontrolled burn. That black chemical mushroom cloud that engulfed East Palestine and our surrounding communities throughout the state of Ohio and the state of Pennsylvania. We have heard the media's narrative over the past year that vinyl chloride burned on that train. However, vinyl chloride was one of the many horrific toxic chemicals, such as benzene, butyl acrylate, and acetone. In addition, there's been no mention nor acknowledgement about the Ford Mavericks and vehicles containing huge lithium car batteries that burned over the first 24 to 36 hours, releasing mercury, arsenic, lead, lithium, and many other toxic heavy metals into our air, water, and soil. And I'm here to say that I am a witness to hearing those batteries explode. I testified last February 2023, 20 days after the derailment, that I heard multiple explosions Friday night into and throughout the day on Saturday, into Saturday evening on February 4th, 2023. I know now that that's what was exploding. It was car batteries. And no one is discussing this. Why are they keeping this a secret from us? We are adults and we can handle the truth. We just need to know the truth. Please just tell us the truth. How did we get here? The ill-fated decision by Norfolk Southern to conduct a controlled burn of 5 derailed cars that were already cooling down. Residents were told 1 tanker was going to have a catastrophic failure, not 5. And further, we have since learned from Jennifer Homendy, chair of the NTSB, that the burn that unleashed the poisonous plume of toxic chemicals in East Palestine, Ohio, and into Pennsylvania could have been avoided. Imagine that. Our lives were totally devastated. And we learned a year later that the toxic plume of poisonous chemicals was not needed and was uncalled for. In addition, Ms. Homendy testified that the contractors employed by Norfolk Southern lacked the scientific background to decide whether a vent and burn was necessary to avoid a chemical reaction that could cause the cars to explode. Did you know residents are being told by scientists and doctors they cannot treat the chemicals that are in our bodies, but they can treat the cancers the toxins and dioxins will cause? Nosebleeds, rashes, hives, swelling, chloracne, respiratory illnesses, migraines, blurred vision, urinating, and the passing of blood are now normal within our lives. Among women, including myself, there are reports of severe menstrual issues, including the passing of large blood clots to severe bleeding, and cycles are stopping completely with no medical explanation. And we have teenagers in our community that have been having to go through colonoscopies because of severe stomach pain and intestinal issues. There are reports of memory loss, neurological issues, seizures, PTSD, which I have a full diagnosis of, and other trauma-related issues are now a reality. What we're witnessing over a year later is now an enormous medical health crisis in the making, physically, mentally, and along with complete financial ruin and complete brokenness. This is wrong, and our government has failed us repeatedly. My father, Larry Davis, was a Vietnam veteran, and both of my parents encouraged me to stand up for what is right and just. That is why I am here today, to give my testimony and repeat my testimony and take a stand against Norfolk Southern. This is a fight I began a year ago, and I will continue. And I am proud to stand beside the strong, intelligent, courageous, and brave voices that have stood up to the injustices Norfolk Southern has inflicted upon our communities. Each one of us can only speak to our story and our truth, but one thing we all have in common is this disaster has destroyed friendships, family relationships, and devastated a once close-knit community. Finances are also destroyed. I wanted to add that. We moved, and you cannot find a comparable home in the price range and the financial stability that we had in East Palestine, Ohio. We physically and mentally cannot remain in a home that we loved for 30 years. Uh, I believe over 200 homes have been placed on the market, many at financial loss, including my own. My American dream, our American dream, and our forever homes are no more. Norfolk Southern must be held accountable for their criminal negligence and their crimes against humanity. We watched as they laid tracks over top of the contamination to get those trains back into operation, as if our loved ones and our communities didn't exist. The burn was not needed, it was unnecessary, and was based purely upon their pure greed. Norfolk Southern caused these tragic events. So why are we being forced and left to beg Norfolk Southern for help? Residents are demeaned and demoralized by Norfolk Southern representatives when seeking assistance. We should not be forced to beg for help from the ones who destroyed our lives. We did not consent to this. I did not consent to this. I have one life. I am given one life, and I do not consent to this to be my life. I made it a point to never go to Norfolk Southern to beg them for help. I have not set foot in their assistance center, nor will I ever. It's not the plan that I had for my life, for our lives, my family's life. We are broken and we want to be made whole. Our state could easily go after Norfolk Southern to get reimbursed and help us first. We shouldn't be forced to go and beg the ones who abused us for help. My mind wanders daily. Will cancer hit a year from now because we are breathing in toxic chemicals? Will I be alive to see and hold a grandchild one day? Will my husband and I ever be able to sell the home that we cherished and loved for 30 years? Our home has been on the market now for over 300 days, I believe. We have lowered the price 4 times. We're currently working on trying to sell it to buyer number 5. Will we ever be able to sell that home? That's where my husband proposed to me. That's where we have so many memories of raising our son Austin. I didn't want to leave my home. That was my forever home. You know, my son's measurements are on that wall. How do they make that right for us? You can't make that right. I stand there and I hear the trains, and I was taken back to the night of Friday, February 3rd. And I'm never going to have that sense of safety and peace and comfort I had in my home prior to that night.
Lonnie, I think that might be a good way to conclude. Thank you so much.
Thank you.
Um,
Thank you.
Powerful statement. I think our
Thank
next speaker will be Chrissy Ferguson. Chrissy is another one of the people who's been displaced from her home. Your turn, Chrissy.
Thank you. Thank you so much for allowing us a chance to share a fraction of our story. My family moved into our home in 1970. My great grandmother had the home before us. Childhood memories, first steps. It was our home, our safe place. Well, on February 3rd of 2023, Norfolk Southern's train derailed. The events that followed that is a battle that we will fight for a very long time. We left our home that night. I had to call the non-emergency police department number to see if we were being evacuated, because I had a dear friend call me and say, "Where are you?" I'm like, "Getting ready to go to bed." She's like, "No, where are you going?" I'm like, "To bed." She says, "We're being evacuated." The train derailment, I had walked up, maybe 500 feet, 600 feet from my home to the Family Dollar. Because we were hearing the sirens, and I was overcome instantly with burning, with burning in my eyes, nose, throat. I thought the mill that was the next block up was actually on fire. 2 seconds like this, took a picture, ran back home, had to wake up my elderly mother and stepfather. We my daughter and her boyfriend had taken the dogs to his grandmother's. My husband and I took my parents to a hotel in Columbiana. The hotel was a financial burden. We weren't planning on that, and it was expensive. Our information page wasn't sharing anything for our community, and there wasn't enough information. The news channels didn't know what was burning. Our firefighters didn't know what they were being exposed to. The lack of information for people caused a great impact on their future health. And I truly believe that. We didn't know it was vinyl chloride in the next morning, and we didn't know of all the other chemicals from their bomb train that rolled through. We had no clue. So we decided to go back home because through Facebook, people hadn't left. People were posting pictures of the fire. They were right up at the derailment filming this. I hadn't locked our door when we left. I hadn't taken any clothes. I left without a toothbrush, without socks. I had slippers on. I grabbed my parents' medication and their things, and we fled. So we went back that Saturday. First we had went into town, my husband and I, and the town smelled. It did. It had a bad odor. I think we were kind of in shock at that point. Well, when we went into our house, it hadn't smelled yet. It was just on the outside. So we brought our family back, and we spent from noon on Saturday until 7, 8 o'clock Sunday morning when they knocked on our door and said mandatory evacuation. Upon lifting that evacuation, and as we were all, the whole community in hotels, trying to find out information, and still was not getting the proper, correct information for this, they lifted the evacuation order. When I went into town and I walked into my home, I became very ill. It hit you instantly. I had Michael Regan and Deborah Shore from the EPA come to my home because through CTEH air testing, the results that the air tester had wrote on my paper did not match the results that she actually had on her device. And the EPA would not divulge theirs. She had to ask 3 times, like a drill sergeant, and order an EPA agent to tell me what my results was. So I had went on an interview to discuss this because I wanted people to know that they may not be getting the right information, because people had videotaped their air testing, Facebook lived it, everybody had ones. How could somebody have their home smell like mine did have Michael Regan on an interview acknowledge the chemical smell in my home. All of them did. Sherrod Brown, Bill Johnson, Morning Journal, Fox News, everyone, and from Ohio EPA, they all acknowledged this odor. And the headlines for the interview was Michael Regan witnesses residential air testing in home. That was very misleading. After he acknowledged the chemical smell in my home, he bolted. He got out of there and went to the park and gave a press conference. It was EPA Superfund Region 5, Andrew McGuire, that did my air testing along with another gentleman that I can't remember his name. Their results were higher than what CTEH was, but they go by parts per billion, parts per million. I have those results. I will share those. I believe I have shared them with you. After I was told that the levels that they had, and it was a 60 and a 50 and a 40, I said, let me guess, everything's still okay and I can bring my family back. Nod. And I said, you know, the smell in this home is bothering me, and you know I'm not bringing my family back. Smile came to the face. I understand. That point, I was deemed a special circumstance. I was deemed a special circumstance by the air tester also. And floodlines, water, cracks in the foundation. There's a whole report about why my home was deemed a special circumstance. And their recommendations were to tear down my home, the home beside me, and the home at the beginning of the tunnel at the creek, because the chemicals were too heavy. There was too much damage. I have fought Norfolk Southern since November of this past year, 23, for that document. They will not provide it. I learned of that document at the command center. I learned that I was deemed a special circumstance, and I heard her tell Norfolk Southern her recommendation was to tear down the homes. No, can't we just have HEPACO cleanup? No, they can't be cleaned. She stood firm on that. But I need that document. That is not fair. That is something I am now being forced, because I continually speak out, they want to end the relocation for my family and send us back to that home. Or I have to join the VAP program from Norfolk Southern and put a contaminated home up for sale to push on another family to cost them possibly their life, because this is their way of making it right. Well, we all can't have bad luck, and I've had a lot of it lately, and I'm still standing, and that's through the grace of my God. So I would love to see that document be forced to be viewed. And it, I believe, was in the discovery of elite attorneys in the class action settlement. And I find that very disturbing. I find it disturbing that people had their homes tested and cannot obtain the results. I've had my home independently tested by a man with incredible integrity, and I know what those results are, and I know what was found in my home, but yet I asked if you want me to clean out the home, rent a dumpster. So I called the garbage company that's handling that. I told them my home's contaminated. I gave them the EPA number. I gave them Norfolk Southern's number. I've shared some of the testing that was open to the public through media. And yet they told them no, because I felt my belongings when I have to throw away everything in my home, put it in a toxic landfill. They're
Lucy, I
saying
think
no.
you kind of reached the point for a conclusion with that bottom line. Thank you so much. And our
Thank you.
next speaker is going to be Courtney Miller, another displaced resident. Courtney, you're on.
I'm going to be fairly brief just because the time constraint, but in my own experience of what I've dealt with, Norfolk Southern was supposed to help me as well after all of this had happened. And my personal situation, my house was in pre-foreclosure and I was in the process of getting it out of foreclosure 3 days before I had filed with the state of Ohio to help me keep my home. And once the train derailed, I knew all of those chemicals were so toxic and so bad that I just didn't want to live there anymore. I didn't want my kids to be subjected to it. I knew that those chemicals were mutagenic and carcinogenic. And I haven't shared this with many people, and it's really hard for me to share now, but not only did I get forced out of my home, but in the process of being out and homeless, I ended up pregnant. And I had to make the horrible decision of whether to keep this child or have an abortion, knowing that at this point I have no stable home environment for my child to live in. And this child could end up with cancer. This child could have birth defects. And what kind of life would this child have? So I made the horrible decision and I had to. And I had an abortion. So not only did they take everything that they took from me, but partially my sanity, the PTSD that I have, that nobody wants to talk about, the stigma that people have when it comes to mental health, and it mentally affected us all, not just physically. And this past Tuesday, I wasn't feeling well. I went to the hospital. I have now been diagnosed with colitis, ovarian cysts, kidney stones, and lactic acidosis, which it was affecting my heart, and microcytic anemia. They can't figure out why I'm anemic, but I've been anemic since March of last year. Prolonged anemia can cause neurological issues. And literally, I have no answers. It's just more questions and more testing that has to be done. I'm just glad that I got my children out of there and I didn't let them go back, and they don't have any issues and they haven't had any issues. But I just had to go back because I just wanted to help the people that were stuck there. So I'm the girl that threw the rock in the creek that made all the noise and started stomping my feet. And thank God this amazing man, Scott Smith, found me on Twitter, and we started our adventure to prove how corrupt they are, how evil these people can be, and everything is a dollar sign. Well, guess what? Our lives aren't dollar signs, and we don't want to give this minor little $600 million. That's supposed to be for us for what? It should be 600 million each for the stuff that they put us through. Our children should not have to go through any of this. It's just, I don't even know. There's like no words for the horrible stuff that we are all going through and will continue to go through until this is resolved. And even then, it's a lifetime of what if we have cancer? What if we're going to end up with cancer? So it's just, that's all. Like, it's just one thing after another. And I just want it to end. That's all.
Thank you very much, Courtney. Our final panelist is the Creek Ranger. I'm honored to introduce Dr. Rick Seid. Rick, you're on, if you want to put on your camera.
Okay. basically, I just want to say that I can attest to myself getting very ill several times going into the creeks. The first time was after watching the news about 2 weeks after, in the EPA saying that, they contained most everything. And my wife was so concerned, and I was more optimistic because of what they were saying. So I said, well, let me go see. I said that to myself. I stopped after work on a Saturday and I started digging the creek. And I came home and I told my wife, we are effed, because there were chemicals everywhere. I was expecting to see a clean creek. And that's what started me filming the creeks for the entire year and some odd months. But that night, first of all, I know a lot of people are suffering PTSD, and maybe I am as well. But this is not. People will say, "Hey, well, you made yourself sick through stress." I have at one time run 4 successful businesses at one simultaneously, and I'm a very type A personality. I've never had acid reflux in my life. I don't get sick. So that night, so I lost when I say I don't get sick, I did catch COVID when COVID came around. And I still to this day lost a lot of my smell. I used to have an acute sense of smell. In that first video that I'm exploring the creek, you can hear me ask, hey, I wonder if I can smell these. And I'm putting my nose down to the water, and you can hear me smelling, sniffing really loudly. So that was the initial time I got sick. That night, I had horrible nightmares. And the reason I believe I had nightmares is because when I woke up, my joints were on fire. I had a burnt streak. Actually, before that, I was in the creek for about an hour, and I was talking to my friend in New York, and I said, wow, I'm getting a headache, and I don't get headaches. So by the time I left the creek, it was as if, I can't even tell you really what headaches feel like, but there was a pounding in my head. But I woke up about 3 a.m. from a nightmare. My joints were on fire, and I had a burn in my nasal cavity, into my throat and down into my chest, almost like a stripe of a burn. But I had to get up. I ran to the bathroom, and I had just explosive diarrhea, and that continued for 4 to 5 weeks. I would have to leave patients in their treatment rooms and run to the bathroom. I don't think I had a solid bowel movement in a 4 to 5 week period of time during that. And that has happened 3 other times since then, in the past year since I've been to the creeks. Acid reflux, so bad that I know there's heartburn, but it was a more intense, as if like a spray bottle was shooting into my mouth, burning my tongue, burning the inside of my mouth. I take no prescription or over-the-counter drugs of any kind. One of my staff members had to go out in the middle of the day. I said, you got to go do something, and maybe she grabbed me some over-the-counter Pepsid. And that repeated itself 3 different times. Shortly after that, I visited the aerators when they changed them from 3 to 24 in the park. And I was filming like a fool so close I didn't have my PPE, and I was actually getting hit by the water from the shower heads, I'll call them. That night, I was taking a shower about 11:30 late at night, and I'm feeling on my back, and there's a lump that I have a picture of. It was about the size of a small teacup saucer. And the only thing I can compare it to was it felt like the consistency of a jellyfish, like the texture of a jellyfish, very soft. And I thought, my thought was, well, come on, it's too early for lymphoma. This has to be a histamine reaction of some sort. That lump lasted 4 days before it went down. So I, in essence, was poisoned. And I will tell you that I'm not a conspiracy theorist. No one can tell me that I did not get sick from those chemicals. And if I got sick from those chemicals, what about the people right down by the crash that are living with those chemicals 24 hours a day, 7 days a week? So I could go on for hours, but I just want to affirm that I had gotten very ill several times from those chemicals.
Thank you, Rick. Dr. Say, you've paid a high price, but you've been a hero to your community. Our next panel, folks, is going to be on the scope of the whistleblower investigation and the scientific dissent. And we'll be starting with Leslie Pacey. Leslie leads Government Accountability Project's environmental work, and she's been leading this investigation. Want to give us a summary of your work, Leslie?
Sure, I just had to unmute there. First of all, I'm a senior environmental officer for GAP. I've been working in East Palestine with residents and researching the community since last summer. First of all, I want to thank Lonnie, Chrissy, Rick, and Courtney for sharing your stories. It's so gut-wrenching to hear them, and I think the majority of people have not heard those, and it's life-changing, honestly, to hear them. And it's why we do what we do. I'm going to be brief. We started our investigation last summer after, just kind of watching what the EPA wasn't doing, right? They didn't seem very interested in dioxins. We would hear about Scott Smith doing his thing and finding dioxins in the community. And we reached out to Scott. We were very concerned. We were hearing about the health issues and whatnot. So, basically, for those of you that don't know, Scott's going to talk a little bit later, but he's been in the community for dozens of times, doing multiple rounds of testing. And he has tested everything from, the soil to furnace filters to crops and the water in the creeks. So he's done incredible work. And so we started working with Scott right away, and we started rolling up our sleeves, and we did some Freedom of Information Act requests to the EPA. Our first request had to do with dioxin contamination and Scott Smith. We wanted to know what the EPA was saying about him. The EPA pushed back, and we ended up having to sue them because they denied our expedited processing request and our fee waiver request, which is the first time in 46 years that Government Accountability Project has ever been denied a fee waiver for one of these public records requests. We actually sued the EPA over that and won. And we found out some interesting things from our FOIAs. One of the things that we found out was that they were kind of following Scott Smith around, trying to figure out who he was, where he was, and what he was doing. And we also found out that just many other disturbing things during the course of this investigation. The EPA was saying all along that there was no need for dioxin testing, that this is not anything that they're going to do. And they finally acquiesced to that in March of 2023 under quote unquote public pressure. We found out later, and largely with the help of Scott Smith and his research, that the EPA had buried some 1,500 pages of documents that they had already knew that dioxin was in the community. It was at the train derailment site. They did some waste sampling and found 19 times higher than EPA's own actionable levels. And yet they were telling the public that everything was safe, that there was no concerns. And so when they did eventually launch their own soil sampling and into the community, they also didn't come up with very high levels of concern. But bear in mind, the EPA has been allowing Norfolk Southern to do a lot of its own sampling and testing to deem the environment safe, to give everybody the go-ahead not to worry. And we find that a huge conflict of interest and very untrustworthy, really, based on the symptoms that we're seeing amongst the community members and what our independent tester, Scott Smith, has found out, and some other independent groups have found out since the derailment. We learned that the EPA allowed some of these contractors to come in and test the homes. Indoor air quality also turned out to be okay after CTEH went in. Later on, we find out that, the apparatuses that they were using to check for these chemicals were not even picking up or going to look for certain chemicals of concern, and that butyl acrylate was incredibly they were unable to detect it at the low levels that it could still be dangerous. And yet they didn't repeat indoor air testing and have refused to do any indoor air testing. Scott's about the only person that has done this for the community. And we also learned that the lazy fires that were burning for 4 full days were quite dangerous. They released about 5 times more toxins and dioxins into the environment. Many of the community members were not evacuated during that time, and they were not aware. They were not given warning that this was a problem. I mean, I've heard stories of children going out to the derailment site after the derailment and being out there with nothing on to protect them for many minutes, and they're now still sick. I've heard some terrible stories like that. We learned that from dioxin expert Dr. Stephen Lester that the community soil sampling plan by Norfolk Southern, done by contractor Arcadis, was, as he says, not worth the paper it's written on, that it's unscientific. We learned that Scott Smith found high levels of dioxin in the garden produce in East Palestine, and EPA did none of its own testing, relying solely on testing by state sources that only looked at volatile organic compounds, didn't even look at dioxins. Yet, the EPA told everybody, go ahead and eat from your crops. Go ahead and eat those crops, and multiple times told them that, and to eat the wild game. We contend that through a petition that we filed with the EPA last week, that they have a duty to warn residents not to eat from their gardens, and they must test enough to let people know that, you know, this is not safe, or it is safe, but they haven't done the testing. They haven't done the work. And we learned through our amazing whistleblower, Robert Crowdle, who's also here tonight, that the EPA failed to fly its Aspect aircraft. That's the aircraft that the EPA's best technology. Robert created the software that goes on this airplane. It can pick up some 500 plus chemicals, and most of that in real time, or some of that in real time. And it could have shown the phosgene in the air. It could have shown the benzene. It could have shown a lot of these chemicals that are highly toxic, but they didn't fly it till day 5. And they don't have a good reason for that, but they have defended themselves and said, well, we really, you know, we didn't fly because of the weather, or other reasons, but it breaks protocol. They always get this airplane out within a few hours. And for some reason in East Palestine, the airplane didn't fly. And when it did fly, it flew over the creeks and failed to turn the sensors off over the contaminated creeks that Rick was just referring to. They were visibly contaminated with chemicals, and you know, both flights, same day, they only collected 8 minutes of data and managed to turn the sensors off over the creeks. So that doesn't look great. We just filed today, this morning, we filed another letter to the OIG, a very detailed letter rebutting the EPA's concerns that they said, well, we have all these excuses for why we didn't fly this aircraft, and we went line by line on their excuses and dismantled them. So that is now in the investigative hands of the EPA OIG, and we're hoping for a very good investigation here that will be continuing on this issue.
Leslie, is that rebuttal in the index of documents that's available to everyone who's watching?
It is. It's the last one on the list, so they can read
Thank
that.
you.
Okay, sure.
I think we're going to have to turn now to Scott Smith.
Sure.
For anyone who hasn't been following this issue, Scott has been the citizen whistleblower who's been the catalyst for holding the government accountable. He's an independent testing expert and the CEO of US Biosystems, as well as a nationally recognized expert on the detection and remediation of chemical contamination. Scott?
I have been to East Palestine now 27 times with 31 rounds of testing, and I want to start by thanking the Government Accountability Project, Leslie Pacey, Tom Devine, the legal team, and the entire communications team, because I would have had Leslie not reached out to me in September, I would not be able to continue to fight for the truth for the community. And I can tell you I have reason to believe some potential whistleblowers are listening, and I can tell you, you can go anonymously. You can trust the people at GAP. You know, they will protect you. They will literally protect your life when you start getting harassed and threatened by the billion-dollar companies and the government agency. I also like to thank the scientific team around me. And before I get started, I also want to talk about, the expression, all the testing, you can't find what you don't look for. I think that from kindergarten on up, PhD, no PhD, high school graduates, everybody involved in this can all agree that you can't find what you don't look for. For example, if you don't test Christy Hilton's soil, you're not going to find anything. And that's how simple this is. And like whistleblower Robert Crodel, if you shut the sensors of the airplanes on the creeks, of course, you're not going to find anything. And one thing I want to address is also for the community. I get a lot of calls. I am not here to give advice. It's everyone's personal decision whether this to opt in, opt out. But what I can say, it is my opinion, this July 1st date, and when there's a lot of information available and it's not transparently being shared with the affected residents of East Palestine and including those in Pennsylvania, that hopefully will be corrected. I also want to say that the smears, the defamation against me coming from the EPA and others and, lawyers, that's a small price to pay to help and do the right thing for my fellow citizens in East Palestine, Ohio. And I say to everybody, whether you're 30 miles away or 3,000 miles away, you need to pay attention to East Palestine, because the next time it could be you. And my offer remains open, whether it's the plaintiff's lawyers experts, and you're going to see here in a few minutes the July 27th, 2023 email. My offer remains open to sit down with the EPA, no matter what they say about me, anybody. I will transparently share my detailed data as long as it's reciprocal. With that being said, I think it's time to share screen. I'm trying to figure this out.
There's a menu at the bottom of the screen if you put your, there you go.
Okay. I wanted, so can everybody see this? Everyone can see my screen now? Tom?
Yes, well, I can.
Okay. Well, I want to address an issue because the EPA and a lot of people have been calling up media and saying Scott Smith is in business. He's a businessman. You shouldn't believe him. Well, I'm here to say, yeah, Scott Smith's in business, a businessman. So what? So is everyone else. And I want to start, Thomas Edison, by the way, was born in Ohio. With no high school education, still remains the most prolific American inventor with the most patents ever at 1,093 US patents. Thomas Edison was also in business and is actually referred to as a scientist. Its definition of science is acquiring knowledge in a systematic way. So I have a feeling that if Thomas Edison were still alive and he would have been doing testing and he didn't agree with the EPA's narrative, they probably would have said similar things about him. So, and I want to be clear too, I'm an inventor on 25 patents and I am in business. The point is, Thomas Edison did not have a high school degree, still is the most prolific US inventor with 1,093 patents, and he's referred to as a scientist. Well, I'm not as prolific as Thomas Edison. I do know what I'm doing with testing for dioxins and other chemicals given my patents and experience. I also want to say you do not get patents without rigorous third-party testing, and many of my patents are related to environmental testing. And this all seems obvious, but I want to make it clear. Plaintiffs' attorneys and their experts are in business. Every media company is in business. Tax-exempt organizations / nonprofits are in business. Ex-EPA attorney Davina Pujara, who now represents Norfolk Southern and subpoenaed me in my driveway, is in business. Academic university researchers are in business. Everyone listed above is in business and generating revenue, which includes bringing in grant funds. And that's a good thing. I don't begrudge anybody for being in business. And this should be about the community and the testing and everyone working together that cares about the community, sharing in a transparent way without distraction. So this makes more sense now if you look at Jennifer Hamady, Norfolk Southern, you can see an example here where Norfolk Southern is controlling the contractors. And I'm going to go really quickly because there are 2 videos I need to play, Tom. So, and this will be available. So everything makes more sense after Jennifer Hominy came out and she was threatened by Norfolk Southern. She's not the only one. Chain of custody, this comes from the 1500 documents with, that Leslie referred to that we found. And here you have, in these documents, this was buried. And I offered to sit down with the EPA. They don't even list the sampler. This is their chain of custodies. I would share these details in reciprocity, but they refused. And they have the lab to generate composites. Jennifer Hominy talked about Norfolk Southern manufacturing evidence. So it is really not a stretch to think if they manufactured evidence to NTSB, what are they doing with the testing? Because the EPA doesn't really do the testing. Most of it is the Norfolk Southern contractors. Here you have an example of a fingerprint and what the dioxin TEQ is, even averaging it. And this is footage of EPA Mark Durno that speaks for itself.
Sure. My name is Mark Durno, MARK, DURNO, EPA, on-scene coordinator for the Flint drinking water response. Today, we did a small talk about the lessons learned from a lot of our community engagement and working with non-government organizations during the Flint drinking water response. This venue is a regional response team meeting, which is a combination of EPA, Coast Guard, state, and federal partners who do coordinated communications regarding spill response over our 6-state region here in Region 5.
Cool. And can you just tell me a little bit about how you first encountered Scott and what that encounter was like and how it's evolved? Sure.
So Scott and I originally met in March of 2016. We knew that he had been collecting environmental data in Flint, and MDEQ and EPA were interested in what information he had. So we met initially, and we had some disagreements initially about the type of data that he was collecting. And over time, as we understood his sampling methods a little bit better, he understood what our sampling methods were intended to demonstrate. We mutually figured out where each other's data applied to the whole of the response.
And what about Scott's sampling? First, did you disagree with, and did you still disagree with it, or did that change?
Well, he has 2 different types of method for general water sampling. One is grab sampling methods. His grab sampling methods are very comparable to the EPA methods that are used to evaluate compliance with regulations. Those grab samples, his data and our data, we've compared them side by side, and they look almost identical. So we do not dispute his data. Now, we did not specifically review his on-site methods, but again, the data is so comparable that we certainly don't dispute his information.
And just with regard to how Scott interacts with the community, and what have you observed, and is that an asset in terms of?
So Scott clearly has a strong rapport with some of the very vocal, very concerned, and very active community members, residents who choose to get engaged, become informed. They certainly utilize his presence to learn, and so that's one of the reasons that we're certainly interested in sitting down with those residents so that they can see how all the information is being utilized. And knowledge is power, and the more knowledge we can give the community, the better.
Okay, cool. So, and just last question. In your opinion, is Scott a scientist?
Well, I've never worked with him until this response. He certainly understands environmental sampling. He certainly understands how to use appropriate laboratories, both for the chemical work that he's doing, the biological work that he's doing. So from that perspective, he seems qualified to collect samples and collect and share data, certainly.
Scott, thank you very much. We're going to have to go to the next panelist for everybody to get a chance. We'll be putting the next YouTube link on our website with an explanation of how it reinforces what Scott has told us already. For anybody who's watching, this is directly contradictory to Mr. Durno's current perspective after the East Palestine accident and the credibility of Scott's work and data. Scott, if you can get us off the shared screen, I want to give a chance now to Dr. George Thompson. Dr. Thompson is a nationally recognized expert scientist and toxicologist who's published over 50 published papers that are related to what happened at East Palestine. And Dr. Thompson, are you here and can you get on now?
I want to talk about just 4 topics tonight I picked out of a lot of the toxicological assessments that I've done for the East Palestine train derailment and fires. I'm not going to go through all of that, but these just simply focus on 4 charts that are current analyses. The first chart here is that I want to look at, there are 4 reasons that I think this settlement agreement has made mistakes. The first reason is that the settlement agreement defines the potential exposure area as a 20-mile radius around ground zero. And I've reevaluated the NOAA high split air dispersion model. I didn't do this work. I just looked at the data that was available online. And the important thing here is that they identified several different plumes that came from East Palestine. There was a northern plume that went all the way into southern Canada, a range from Lake Huron all the way across to Lake Ontario, included much of New York, northern Vermont, and New Hampshire. And it covered about a 300-mile span compared to the 20 miles that's allowed in the settlement. There was an easterly plume that covered all of Pennsylvania, northern New Jersey, and stretched for about 600 miles towards the east. There was a southeasterly plume that went down through West Virginia, Maryland, Delaware to Washington, D.C., and that distance is about 285 miles. In my calculation, this encompassed about 126,000 square miles, which is about 100 times more than the radius of the 20 miles allowed in the settlement. It affected 8 states, exposed millions of people in 2 different countries, actually. The high split system was an hourly analysis. It assumed only 1 million pounds dispersed. In my calculations, there could have been 8 million pounds, over 8 million pounds dispersed. So they had a low number, but they did have this hourly analysis. And the other fault that I see in the system is that they ended this dispersion period on the 7th of February, and we know there is still smoldering going on till at least the 8th. I'm not sure why it ended at that point. I'm in the process now of identifying some of the other dispersion modules so I can compare them here. But the point is that with the NOAA system, it is definitely not just a radius of 20 miles. The next thing I want to emphasize is that the East Palestine fire was apocalyptic. It created a chemical stew. And this is an unprecedented event. In my 55 years as a toxicologist, I've never known an event that was this dangerous and hazardous. I put in here just some of the chemicals that I've identified created by the fire, but there is no epidemiological information that you can go into the medical or scientific community and determine how you assess the toxicology of this kind of a mixture approach. Even the legal law depends upon you showing causation by a single chemical. These people were not exposed to a single chemical. They were exposed to a stew of chemicals simultaneously over a relatively short period of time. And so as I was talking to somebody this afternoon, not long before this presentation, this event changes our view of chemistry. What's happening here in this reaction? I can research and tell you what chemicals were on the train and what did they produce in the fire from this partial combustion. But I can't tell you what's going on in the fire. Did these chemicals further react with each other and change either into other hazardous chemicals? That's unprecedented. It's unprecedented on the medical side. The medical side is all of these chemicals produce different kinds of toxicology, short-term and long-term. And this is unprecedented because of the mix that's involved here, the mix of medical conditions. There are many of these chemicals, for example, produce headaches, nose, throat, lung irritation. Many of them do. And so you can't identify what is the chemical that caused that, which is the normal process in the legal arena. So when you involved in lawsuits, and I've been involved in 54 of them before and a new one this week, but you have to show causation. Causation means, in specific causation, you have to identify the chemical that produced the medical effects, the symptoms that you're suffering from. You can't do that when the exposure is too astute. And many of these chemicals produce the same kinds of injuries. The third point that I think the settlement agreement does not incorporate is the idea of expected latency periods from the fire-generated chemical stew. We know that in 9/11, what got our attention were the deaths in the first few days. About 3,000 people died. Very few people are aware that in the 20 years since then, an additional 4,300 people have died from that event. And there are over 71,000 people that are suffering from physical, mental health conditions due to their exposure to the stew that occurred after 9/11. As I look at East Palestine, this apocalypse is very much more insidious than the 9/11. It's insidious because it's unprecedented. The misleading part is that there were no deaths. So the EPA administrator and the Ohio governor come out and say within just days, East Palestine's safe. Your water's safe, your soil's safe, you can raise your gardens, you can do whatever you want. That announcement brought me out of retirement to work on the East Palestine problem because I knew that that could not possibly be true, that within days they could say that. Now, a year later, we have accumulated enough data, and a lot of it from Scott, that's proven this was wrong, that it wasn't safe then. And in fact, one of the residents there outside of East Palestine has tabulated 95 different medical symptoms, these mystery illnesses, if you will. We know that there were animal deaths at the early onset. There have been people in Canada near Niagara Falls that had the same kind of headaches and irritation symptoms that the people in East Palestine had. And they had this during the week of the East Palestine plume dispersion. We know that in April, several months after the initial event, 7 CD workers went to East Palestine and immediately came down with the very same medical symptoms. In March or late February or early March of 2024, a graduate student from Texas A&M came up to talk to the people in East Palestine as part of their project, and she developed the same symptoms that everybody else did. This is over a year later. There are chemicals in that environment that are causing outsiders to become sick when they come in. And one of the big things that I've read almost nothing about is that these chemicals that are there have the potential of contaminating the nation's food chain. Materials that are raised, animals that are raised get into the national distribution, and you get the food chain contaminated. So there have been multiple exposures. 119 chemicals that I've identified could cause cancer. 21 different organs and organ systems in the body are known to develop cancers from these chemicals. The petroleum trace elements that are involved in the emissions, some of those promote cancer caused by other chemicals. So you have this dynamic combination. And the fire-produced chemicals cause many other serious non-cancer diseases in 9 different organs in the body, such as the brain, liver, kidney, and also reproductive effects. So the settlement agreement needs to be amended to require Norfolk Southern to fund ongoing health monitoring and treatment for at least 30 years. my last summary chart is that the settlement agreement does not anticipate the newly funded research for the 6 universities that will provide critical information not previously available to the court. So I've listed here the 6 universities. Case Western is going to be studying residents' experiences and concerns. We already have a lot of that tabulated for them. And then they will initiate a long-term study to evaluate the effects of these chemicals on the DNA, the reproductive chemicals in our body cells. Texas A&M is going to do a mobile VOC air sampling. This may hopefully find some of the explanations for the ongoing effects that people are still suffering here.
Dr. Thompson, excuse me, but we're going to have to, we're going to be putting the rest of your slides on our website for people to study. And I'm going to have you, summarize and close now so that we can get the other speakers a chance.
Fine. University of Kentucky is going to be doing an online survey and establishing a network to disseminate information to the community. That would be a positive. And there are 2 studies done out of the University of Pittsburgh that are assessing contamination of the soil, water, and sediment, home water, and air samples. And this information then would become part of this disseminated information to the community. So those are the 4 areas that I see of great concern and warrant individuals challenging this settlement agreement to be acceptable. My email, if people would like to get in touch with me, is listed here. My name, George Thompson, at chemply.com. Thank you very much.
Thank you for that brilliant presentation, Doctor, and all your slides will be on our website. But let's go then to the third and final panel. It's kind of an assessment of the legal facts of life connected with the settlement that's being negotiated. And our first speaker is going to be Ted Frank. Ted is the leader of the Hamilton Lincoln Law Institute and Center for Class Action Fairness. And so we're honored that, thank you very much for making time to share your expertise with us, Ted.
I'm just here to comment on the settlement from someone with a lot of experience objecting to class action settlements. Nothing I say here is legal advice. You should consult with an attorney before taking any action based on anything I say. I'm not offering or asking to represent any parties in this case. My experience is in class action procedure, and anyone wanting individual advice should be consulting with an environmental tort lawyer, which I'm not. The settlement has 2 main components. There's a property and business damage component for claims for people living within 20 miles. That provision precludes all future claims for property and business damage, whether or not you make a claim on the settlement. The other is a component for personal injury. That's an opt-in component with an August deadline for making claims. If you don't seek personal injury damages from the settlement, you do not release your claims against the railroad or any third party. But the release in the settlement does extend to several third parties, and some suggest that's unfair. To the extent the court will evaluate that, Norfolk will argue that this is necessary for them to settle to avoid collateral indemnification from the third parties and avoid double expenditure. They're settling all of their claims for $600 million on top of what they've already paid. But on the other hand, Norfolk is continuing to sue these third parties for contribution. So it might be possible to make an objection that the settlement can't be considered piecemeal like this, and that the other parties should have been at the negotiating table and chipping in, and that it would be unfair to release them. In terms of what individuals can do, one can opt in, one can opt out, or one can object, but one can't do both. When the court is considering whether to approve the settlement, it'll evaluate objections and the requirements of the federal rules, and it will give it an up or down decision. It cannot rewrite the settlement. That's up to the parties to do. But when the judge, if the judge were to be unhappy with the settlement, she could certainly conceivably tell the parties that they need to change one provision or another, or she won't approve the settlement. People have asked, can anything be done? What's the best way to get the settlement changed by the judge? And the answer is simply, if there's a strong objection, it might persuade the judge to reject the settlement and send the parties back to the negotiating table. But realistically, for somebody complaining that the settlement isn't large enough, they would have to present some pretty substantial evidence that the attorneys didn't know what they were doing when they agreed to this. The $600 million figure what came up in settlement negotiations because they had a mediator. The mediator proposed the number, and the parties accepted it. And realistically, the court is unlikely to second guess that number. But there are other issues with the settlement. This is a strangely constructed settlement class where the attorneys are simultaneously negotiating a lump sum that covers all sorts of different claims, and young people who want medical monitoring for things that might happen decades from now, and older people who own damaged property. They have different interests in the negotiations in the settlement. And theoretically, under the rules and under the law, a class settlement like that should have different representatives negotiating for those different interests. But in practice, courts rarely enforce those concerns, and certainly won't unless somebody raises it in an objection. There are issues with the settlement website that it states inconsistent information about the scope of the release. It makes promises about future medical rights that the settlement doesn't seem to have. But that would be a reason to give new notice and change deadlines rather than to throw out the settlement. The other option is that if you have an attorney willing to represent you and who's telling you that he or she can win you more money, sorry, circling through my notes here, then you can opt out from the settlement, or you can choose not to make a claim for personal injury monies from the settlement and avoid the personal injury release, and then individually sue for personal injury. So that would be an option, but you should understand that without an attorney to make those claims for you, it's unlikely that you could get more than what the settlement is providing. Another potential avenue of objection is that the attorneys who negotiated the settlement are asking for $180 million, which is just a huge amount of money for less than a year of litigation. It's possible that the court might reduce those fees, but I've seen courts sign off on more egregious fee requests than that. We don't know what the fee request consists of, even though the objection deadline is coming up, because the attorneys don't have to submit the formal request for the fees until September, which is itself a violation of the rules because they're supposed to be submitting that before the objection deadline. If somebody is objecting, that's Rule 23H, and the precedent on that is called Mercury Securities. But the remedy for that would probably be to extend the objection deadline. Objecting to the fees might or might not reduce the fees by several $1 million, but it wouldn't make the settlement more than a few percent larger for the class members. Some people have suggested that there's a problem that the settlement has an offset for amounts already received from Norfolk. That might strike some people as unfair because the settlement might ultimately provide less than what Norfolk has already paid, and meaning that the settlement would effectively be canceled out and be given zero. The offset would take them to zero. But one should understand that if one successfully sued Norfolk individually for damages outside of that settlement, a court would apply the same offset. And you should also understand that the offset ultimately doesn't reduce Norfolk's liability with respect to the settlement. They're putting $600 million in a bucket, and that's going to get split between the residents and the attorneys and the administrators, and none of it's going back to Norfolk. Unfortunately, decisions on the business and property aspects of the settlement have to be made by July 1st. It'll be hard for you to get an attorney to evaluate whether you have a stronger claim than what the settlement allows between now and then. But on the other hand, if you're in the category of people who are getting nothing from the settlement, there wouldn't be a cost to opting out. Again, I'm not telling you whether or not to opt out or to make a personal injury claim or to object. You should consult with an attorney who can evaluate your individual circumstances if you're unsure about that. Before this conference, I got a question emailed to me. Why are all the air modeling and suit surface deposition maps not being considered in the class settlement? Why is the payout area circled, but the day of the burn, the EPA suit deposition map is oblong? And, you know, you'd have to ask the attorneys why they chose that model for allocation. They could have a reason for it, but they could have just been thoughtless about it. And if so, that might be something objectionable that the court would consider and send it back to the drawing board, depending on how much evidence there is that suit deposition is more important than distance. Even if a ring system was appropriate, the grid has a lot of arbitrary components, especially if you're near the border of one of those rings. There's a big jump from being 1.9 miles away versus 2.1 miles away. So does it make sense to have a pure grid with lumpy distribution instead of gradients? There are arguments both ways, and the courts, unfortunately, will have the discretion to uphold or overrule an objection over this. And just the unfortunate reality is that when you have a large mass tort like this, a large class action is designed to quickly resolve things and compromise. And courts like compromise. They prefer it to resolving thousands of claims individually. It's thus sort of an uphill battle to upend a very large class action settlement that is distributing a lot of cash. But even if the objection process turns out to be unsuccessful, individuals unhappy of what the settlement provides have the choice of opting out. But I think realistically cannot expect to get better results without legal representation.
Thank you so much, Mr. Frank, for that sober, in-depth expert analysis. The community is hungry for it, and it's very much appreciated. Our next speaker, Chris Nidell, has similar expertise. He's a longtime environmental and class action veteran and a partner in the firm of Nidell and Nave. Chris?
Can you hear me?
We can hear you fine.
Okay, great. So I will try to avoid overlapping too much with what we just heard from Ted Frank. And I want to start by for thanking people for sharing their deeply personal stories about the impacts that they had in East Palestine from this event. I am not here to diminish anything that anyone said, certainly not here, as we heard one of the speakers say, to tell anyone that they did not get sick or they were not impacted in any way that they believe that they were impacted. I'm simply here to talk about my experience and my review of the settlement agreement and the process by which the folks, you members of the class are to proceed. And like Ted said, my purpose is not here to give legal advice. You should definitely consult with an attorney. I am, contrary to Ted's role, I am a plaintiff's lawyer that files personal injury cases for toxic torts, very similar to the case in East Palestine. And I have filed individual mass tort or individual cancer cases as well as class actions. The last thing I'll say, just as by way of quick introduction, is that this lawsuit and this settlement is just one piece of what I see as the remedy that the community needs for this event, right? So this lawsuit is not is not the be all and end all. The EPA has a role, the state has a role, local officials have roles, and so there are other things. I know one person talked about criminal penalties. Those are things that a lawsuit, particularly this class action, cannot pursue. And so that's a good example of how this lawsuit is just one piece of the puzzle. The other thing that I would say as a tort lawyer that represents injured and sick people is that, unfortunately, I don't have, and the lawyers that represent the class in this case don't have the ability to make anyone truly whole in this instance, particularly when you're talking about a home that you meant to have for your lifetime, and certainly not for your health or the health of your family, right? So none of us lawyers can bring that back or make you whole in that respect. So now let's talk a little bit about the settlement agreement. The settlement agreement, and I think what I understood from Ted Frank's review, and I would agree with him, is that I don't think a court is going to upend this settlement agreement. There's a large dollar value attached to it. It's a huge complexity of lawsuits if it's not settled as a class. The court may push back on some of the deadlines, but I don't think the court will upend this deal. So that puts you, members of the community, in a position where this is something that's put out for you to either opt into or opt out of. Unfortunately, if you do nothing, you're in the class, right? So that's with respect to the property damage only. But this is not something that you're being forced to take, although you have to do something to opt out of it. But so it may not be right for everyone, and you have the option on the property level to opt out. And then for the personal injury piece, you have the option to opt in. The deadline that's approaching July 1st is for you to opt in, by default or opt out by your action of the property damage class only. There's an August 22nd deadline to opt in to the personal injury aspect. So if you want to make a claim for personal injuries, which are not typically treated in a class context because of the unique variation between person to person, you need to make that election and file that form by August 22nd. There are two claims that you can make for personal injury. One is the default claim that will give you, as outlined in the settlement agreement, and I think in the FAQs, it will give you, some set amount starting. I think the maximum is $10,000 on down based on proximity. And that's sort of a no questions asked amount as far as that award. You would be receiving that award based on, sort of the facts of your proximity. If you want to make an enhanced claim, you can make an enhanced claim, and there's a process to do that in the settlement agreement. Again, that has to be done by August 22nd. The problem that I see with that enhanced claim is that there is no information on how those claims will be evaluated for causation, number one, and for the value, number two. So, and based on the responses in the FAQs and the responses from the plaintiff's lawyers in this case that largely indicate that there is little science that supports a personal injury claim of any long-term effect, my caution is that it's unlikely that those enhanced claims would be significant. It's an unknown, and I guess what I would say is, at worst it's unlikely, at best it's unknown where that would go. So that leaves people who believe that they think that they are long-term harmed, that they face either long-term risk or that they have a serious illness, to, as Ted said and others have said, to consult with an attorney to review the data that they have specific to their exposure, whether that's their yards, whether that's the creek, and those other exposure pathways, and determine if you have a lawyer, number one, that's willing, and number two, if you have a strong case. And if you feel that you do have a lawyer, that you have a lawyer, and your lawyer feels that you have a strong case, then you don't need to opt out of the property damage element. You can stay in the property damage element, which you're in by default, and then you can not file that personal injury claim that would require a release for all past, present, future known and unknown injuries, but pursue that on your own. Finally, what I would say, I think my time is coming up, that if you do have a long-term result, so say you have cancer in the years to come, and you have not filed a personal injury claim by August 22nd, then what you have is the opportunity at that point of diagnosis in the future to pursue that claim and talk to a lawyer about that claim. And since the recoveries would be limited under this agreement, that is certainly something that you should consider in talking to a lawyer, is that, yes, maybe you have a future increased risk of harm, and that harm could be significant. But once you have that diagnosis, you can talk to a lawyer and pursue the evidence for that claim at that time. And I think it was George that showed a series of studies that are being done, and there probably will be more over time, that will look at the health effects that your community has suffered and may provide additional evidence to strengthen a legal claim for these long-term injuries that take that have some latency or take some time to manifest. With respect to third parties, the liability, just to understand that what's being released is it's the liability that Norfolk Southern has if a claim is brought against a third party. So my understanding is that you can bring a claim against a third party. It's not that there is no liability there, but if they bring in Norfolk Southern, any liability that Norfolk Southern has for the claim against that third party, you would be indemnifying them for. So it's a limitation that would have occurred if you had all of these defendants in one case. Again, everyone needs to know that if you do not opt out by the first, you're included in this property damage class. So that's the important upcoming date. The fee, with respect to the fee being 27%, as Ted said, and I don't disagree, it does sound like there has been a lot of work. It was a short time frame, just over a year of discovery. It does sound like there was a lot of work. I don't think a judge is going to upend the settlement based on the fee percentage. So I know those are a lot of people's concerns. One last thing that I will say, I know I think George raised and others have raised the long-term risk and the medical monitoring. I know the class originally pursued a medical monitoring claim. I know that was thrown out. It is an available remedy. As Ted will agree with me, that's never been a claim, or very rarely been a claim that's been certified. So it's something that EPA is working on. It's something that the money that has been recovered can be viewed as going to, but it's something that is very difficult, particularly in this context, to certify as a class settlement. So I see my time's up and I will stop.
Thank you very much, Chris. These last two speakers have been really kind of a straight law lecture on what you can do to defend your rights. Their lectures are going to be on our website for you to consider, and it was good news to us that you have until August 22nd to make a judgment about the threats to your medical condition and personal injuries. Our last speaker, we've heard from the experts about the law. Our last speaker is going to be discussing how this settlement affects the people who live in East Palestine. Jamie Ray Wallace is the founder and has served as president of the Unity Council in East Palestine. Jamie, it's your turn.
Hello. So I became an activist, not just a house mother, on February 3rd, when I was told that it was safe to go back to my home. I told my husband, when he said, what are we going to do when they lift the evacuation? I said, we're going to go home. If the EPA says it's fine, it's fine. As soon as I pulled in my driveway and was overtaken by fumes, chest started burning, nose running, eyes watering, I look over and I see chemicals just free flowing down the stream right next to my house. I realized that the EPA had lied. I couldn't trust them. I actually got the lead toxicologist for CTEH, which is the railroads testers, to come into my house. And they said that I had a pathway to exposure in my basement. The next day, Norfolk Southern offered to move me out. I didn't just take a check and run. I probably should have took the check and then told people in hindsight, but that night was the first town hall. So I went and told my whole community that, they probably were wrong about just my house. The chances of them only being wrong about my house, and I'm the one person with a big mouth, not the one person, but I have a big mouth. I highly doubt that that was the case. So ever since they broke my trust, they being the EPA, on, a couple days in, to the level of my child's life, I've been working with other community members. We formed Unity Council for the East Palestine train derailment. We are just a bunch of everyday average citizens from PA, Ohio, just surrounding communities. And we have been fighting for the truth. In all honesty, I still have not signed up with an attorney. I kept putting it off because human health has always been and always will be my number one priority. So when, I thought, we have a 2-year statute of limitations. They started this lawsuit. It's going to take a while. Next thing you know, we're getting notices in the mail that they did a preliminary settlement. One of my biggest issues is we only were allowed 1 month to make this decision. 1 month is not enough time to gather all of your medical records, especially when people that were relocated were using different doctors. So you're getting these from, different locations. If you were relocated, like I was, Norfolk Southern kept all of your receipts. So you have to obtain those receipts from Norfolk Southern, which at this point, we don't even know where the heck they are. Some people have been able to obtain those. And as they've gone through them and added up those receipts, one of my friends told me that when she added up those receipts, they had added an extra $8,000 to her 1099. Being able to view some of the evidence, depositions, things of that nature. Maybe this is typical. Maybe I'm just, asking for too much. But to me, whatever evidence they have really contributes to my determination of whether or not this is a good settlement. If they have Alan Shaw and the EPA laughing on a video saying, yeah, we dropped a chemical bomb on them and we all know they're going to die and, whatever. But I'd like to see the evidence that they had, in particular, the testing that they did on residential properties. I'm not sure, where that duty lies with attorneys. But to me, if you tested my home environment and found it to be, heavily contaminated, and then you let me sit there for 1.5 years because you want to save that settlement or evidence for the settlement, they still will not release those results. We really don't even know who the lead plaintiffs are. I dug and found a few. And then I asked them, are you a lead plaintiff? And they're like, no. So, some of the things that I feel like we should fighting for is, number one, the reimbursements being taken out of the settlement. While I realize that's something that's typical, I think this is an extraordinary circumstance because in this case, those people that were relocated were the most impacted residents. We can prove that people have different levels of chemical sensitivity. So why are we going to punish somebody because they were sick? Also, they gave like $1,000 inconvenience fee for people being out of their home for 3 days. We didn't want to be out of our homes. I don't know if anybody's ever lived with their daughter, husband, and mother-in-law all in a hotel room for 5 months, but trust me, it's not fun at all. Your kids can't go out inside and play. They're not around their family. Adults can't have adult time with so many people in the room. And then what people didn't realize is once these hotels were booked up, sometimes they would come to your room and tell you, hey, it's booked up this weekend. It's St. Patrick's Day. You're going to have to find some place to go. So then you had to pack everything back up and find another place to stay. Some of the things that they reimbursed us for was gas money. People were driving, sometimes 40 minutes to work because we're in a very rural area, whereas normally they had 5 minutes to work. So I think this is extraordinary circumstances where the people that got the money were actually some of the most impacted residents. I also am not sure that our class representatives actually represent the class because they're all in hiding. I know one of them is my current landlord. He owns 2 huge businesses, probably 40 different properties. I'm not sure if he was ever sick or out of his home, but to me, I almost feel like the classes should be divided differently, or have a subclass of people with chemical sensitivity, because that's the big, huge difference that I see. And, what people's claims and injuries are is, they're the people in town right now who, our town's divided, that are saying we never got sick, everything's fine. They're like, yeah, free $70,000. And the people that were the most impacted, that are highly sensitive to the chemicals, that had to leave their homes, are getting zero. It's almost like it was deliberately designed so that the people that were the most outspoken, which were of course the ones that were sick, are now going to get $0. Of course, I understand we can't be made completely whole, but they are going to be ending up staying in contaminated homes, sick, with no money. So instead of opting out and getting my own attorney, we are starting to fight the settlement to try to object and make changes to it and make it become a settlement that is for the people, and actually, you know, takes care of all the class members' needs and not just the pockets of the attorneys. So if you want to fight,
Yes.
email me.
Thank you so much, Jamie. The residents have been really the inspiration that's motivated us at GAP, both the consequences they're suffering and their eloquence and courage. Government Accountability Project, our purpose is helping people use freedom of speech to challenge abuses of power that betray the public trust. And in our judgment, this is a classic example of betraying the public trust. I hope that today's forum is going to help you make an informed decision about whether upcoming resolutions provide justice for you. But I want to remind you that this panel and this forum is just the tip of the evidentiary iceberg for information that's already been compiled and shared with you. And more is coming in at an intensifying pace. Check our website to keep up with the latest. It's www.whistleblower.org, whistleblower.org. We're not going to be concealing anything. We want you to know the truth and the full extent of what we've learned. Thanks for coming today, folks.